Circuit Court, County of Muskegon is now in session. The Honorable Matthew R. Case was presiding. Please be seated.
Good morning. All right, before the court is file 23110 FC. It's People of the State of Michigan versus Shanda Vander Ark. Are you Shanda Vander Ark? All right, Ms. Vander Ark appears before the court with her attorney, Mr. Ambrose, Mr. Roberts, as well as Ms. Bloomquist are here on behalf of the people of the state of Michigan. Date and time, the court is scheduled for a Ginther hearing, and technically a continued hearing from the last time we were here. We're delayed. There's been some concerns regarding Ms. Vander Ark's health this morning. Mr. Ambrose, if you want to go ahead and make a record of any concerns you have at this time.
Yes, Your Honor. I had a video conference with Ms. Vander Ark on Friday, this past Friday. It was concerning to me because she didn't appear to be her normal self, and so that concerned me. So I did send an email to the court expressing an adjournment if possible, just because this is an important phase in the whole appellate process, and certainly of utmost importance to my client that she's able to participate in a meaningful manner. And during our conversation on Friday, it just didn't seem that she was as up to speed or healthy. She expressed some health concerns that she was undergoing at that time, and so that's why I asked for an adjournment on Friday. What I understand is that what she told me this morning is on Saturday she had an episode at the Huron Valley Women's Facility where she passed out for a short period of time, was revived, but she had a medical issue at that time. She's not feeling well today either. I know she was checked out by medical. Her blood pressure is higher than it is normally for her, as she self-reports. So I would be requesting an adjournment. It doesn't hurt the prosecution, I don't think, at all. It is, if anything, delaying this case keeps her in prison. I'd like to move forward as if I could, knowing in good conscience that we're putting our best foot forward on a case like this, and have the 100% confidence that my client is able to participate in a meaningful manner. And I just don't think at this point I can with any type of confidence say that. So I would still ask for an adjournment, and I know that my client has signed a release for some medical records from Huron Valley Women's Facility to release at least the most recent episode that she had.
Okay, Mr. Ambrose, is she able to speak to you this morning?
Yes.
Not getting into what those conversations are, but are you able to converse with her this morning?
I can.
Okay.
She has a pounding headache, and
Okay.
and it doesn't help. It's a stressful situation. I'm sure that's part of the what happens in these types of situations. But yeah,
Do you have, as an officer of the court, do you believe she's not competent to go forward? Under the Michigan, under the law in the state of Michigan, do you believe she is competent to go forward?
Yeah, I don't think she's
Okay.
Incompetent, put it that way.
Okay.
She's able to communicate with me, yes,
Okay.
but maybe not at the best.
All right. Does she?
Especially with somebody that has a pounding headache. I can
Yeah.
imagine.
Did she take any medication for
I don't
headache or aspirin
I don't think they gave her
ibuprofen or?
any medication today.
Okay. Is that something she normally would take for a
Yes.
headache?
She's,
Okay.
yeah, she has a thyroid issue. Pointed out to me
Okay.
that it's protruding. She's undergoing testing. Won't know the results for another couple of weeks, and
Mhm.
if it's cancerous or not. There is a family history of that as well.
Okay. Ms. Polquist?
Thank you, Your Honor. Well, I was going to argue that she's presumed competent until she shows otherwise, but given that's not the claim, then the argument would be whether or not there's good cause for an adjournment, and it's the people's position that a headache is not good cause. Additionally, the people are ready to proceed and put, one, with the Ginther hearing, but two, we do have some evidence that we could set forth to make the record as it relates to her appearance and how she was on the transport on the way here. We did have after the in-chambers discussion, Jill Medical came and looked at her, and it seems that she's been cleared by them, apart from having somewhat raised blood pressure. So I do think that we could make a record as to why this is not good cause. Additionally, Ms. Vander Ark, through her counsel, did give a waiver of HIPAA so that we could request some records from MDOC. They said that those would be emailed to me in approximately 30 minutes. They were going to do that expeditiously. However, the people would put forth as an officer of the court that in communications with the Michigan Department of Corrections, they would not have transported her had there been a medical issue raised before transport. So, Your Honor, I think this is just, again, another dilatory tactic by Ms. Vander Ark to delay this hearing and to delay the proceedings. And I would say that there's not good cause. And additionally, I think the court can take into consideration all of the prior actions of the defendant, her prior reports, all of that when fashioning whether or not an adjournment is warranted. And it's not in this case, and we should proceed.
Okay. Did anyone, we obviously have the Department of Corrections officers in the court. Did anyone talk to them regarding her condition?
I did, Your Honor. I did inform them they maybe needed to take some brief testimony.
Well, short of that, I mean, are either one of you comfortable doing that?
If you would like us to.
Okay, well, why don't we have one, what's your name, ma'am?
Officer Scott.
Officer Scott, why don't you have you come on up, and I'll swear you in. What's your first name, ma'am?
First name's Autumn,
Autumn.
A-U-T-U-M-N.
All right, Ms. Scott, can you raise your right hand? Smack it up, and if you swear or affirm the testimony you're about to give you the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right, put your hand down and grab a seat. Can you please state your name for the record, spelling your first name and last name?
First name is Autumn, A-U-T-U-M-N. Last name is Scott, S-C-O-T-T.
All right, any objection with me asking some questions, and I'll let you guys follow up.
No,
Mrs.
Your Honor.
Bloomquist, Mr. Ambrose?
No.
All right, good morning, ma'am. I'm sorry you're in this position. This doesn't usually happen, so.
It's okay.
My understanding is you transported Ms. Vander Ark here this morning, is that correct?
Correct.
And where did you transport her from?
Women's Huron Valley in Pennsylvania, Michigan.
Okay, approximately how long is that
About
ride?
2 hours and 45 minutes.
Okay, and now, I kind of understand the configuration. Are you in the back with her in the van, or are you driving in the front? How does that usually work? Where's everybody in the van? Without getting into
It's
too much
okay.
stuff.
I was driving, my partner was in the passenger seat, and Ms. Vander Ark was in the back.
Okay, so you were more focused on the road?
Correct.
Okay, all right, so we probably need your partner more a little bit. Now, were you able to observe Ms. Vander Ark?
I can see her through the rearview mirror as I drive.
Okay, was she communicating with you at all?
She only spoke to us a couple times just to ask to turn the heat up or down.
Okay, did she indicate that she had a headache at all?
She did not when we arrived. She did say that she was feeling a little nauseous,
Okay, all right.
a little dry heaving.
Okay, anything from, was it, okay, all right. You probably, did you ask what it was from? Was it from the ride or something like that, or you don't, you know?
She did say she does get car sick.
Carson, okay, all right. To your knowledge, would the Department of Corrections transport a prisoner if they had a concern over her medical health?
No, and if she would have expressed it to my partner, then my partner would have requested to have healthcare come and clear her before we leave.
Okay, all right. Okay, all right. Technically, Mr. Ambrose, this is your hearing, so unless, if you want to go ahead, Mr. Ambrose.
I don't really have any.
Okay, Ms. Wilquist?
Just briefly, Officer Scott, was she conversational?
She didn't talk much. Like I said, just to ask us to turn the heat up or down for her. Other than that, she was quiet.
Okay, thank you. I have nothing further.
Okay, you can stand down. Thank you so much. Do we want to put the other Department of Corrections officer on? Anybody input on there?
I'll leave that in the court's discretion, Your Honor.
Mr. Ambrose?
I don't have an opinion on it.
All right, any other argument before I make a ruling on this, Mr. Ambrose?
Well, just that she did mention that she was nauseous, and that's consistent with, you know, her headache, which she reported to me.
All right, Ms. Bloomquist, anything else?
Yes, Your Honor, I just would ask the court to take judicial notice that Ms. Vander Ark, during this motion to adjourn, has actually been assisting Mr. Ambrose in the proceeding with writing notes to him about if she's taken any medication or if she has done anything to assist in in remedying her headache. So I think that I just wanted that to be on the record because I don't think the transcript would necessarily catch that, but as an observer in the courtroom, she has been actively participating in this motion through her counsel despite her claimed ailment. So again, I don't think there's good cause for an adjournment, and I'd like to move forward.
All right,
You know, Your Honor, can I just say, I mean, just my client writing a couple of notes down, is that supposed to be some sort of active participation? I don't think so.
well, Mr. Ambrose, we're kind of in a catch-22 because I can't ask you what she's been telling you, and you know what kind of, I can't judge how much she's assisting you without getting into what she's talking about. So I'm observing her writing notes and talking to you, which I've had jury trials where the defendant doesn't say anything to their counsel, and so why don't we do this? The court also has experience with Ms. Vander Ark. Several times during the proceeding, during the jury trial, there were breaks in time where Ms. Vander Ark said she was undergoing distress. I granted those breaks. It seemed to me, and from the outside looking in, that these medical issues seem to be at times of pretty significant testimony in the trial. Not saying that maybe they weren't genuine, but they certainly appeared to be situational. Also, when she were at a preliminary examination down in district court, there was just a point of what she claimed to be distress that appeared to be situational. We're here now, and I think it seems to be situational again. Again, she may be going through something, but I understand that adjourning this wouldn't necessarily prejudice the defense. However, there's witnesses here, they're ready to go, people took time out of their schedules, the court set aside an entire day for this. And there is something to be said for the swift administration of justice here. And so, based on this, based on what I have, I don't think there's good cause for an adjournment based on a headache, because that's all really the record's been made. And the only person that can judge if she really has a headache or not, quite frankly, is Ms. Vander Ark. And I don't know if she's telling the truth or not. I have no clue. I will say, as the finder of fact at the trial didn't find her credible, and I don't know how much credibility the court can lay on her statement. So I'm willing to do this. I can take a break, wait for the records to come in, that way the court can review those. I also can offer Ms. Vander Ark, is our jail staff allowed to give her medication, like ibuprofen or Tylenol or something like that? Is that allowed?
I would assume if they discuss it with healthcare at the prison, that would be fine.
Okay, all right, so I don't, do we have something downstairs that she can, I don't know what she takes, Mr. Ambrose should let me know, I'm sure they have it all on, we can do anything we can to help with that. I'm willing to give her, if she needs for blood pressure, I don't know, maybe she needs food or something, I don't know what it is, so anything that can accommodate to help her headache, I get it. If she's got a pounding headache, then I want to at least try to get her some help for that. So why don't we adjourn, we'll wait for the records to come in. Mr. Ambrose, let my staff know if she needs medication, and we can get that from the jail, and then go from there. Anything else before we break, Ms. Bloomquist?
No, Your Honor.
Mr. Ambrose?
No, thank you.
Okay, we're in recess. 110 FC. People versus Shanda Vander Ark. Mr. Ambrose, did your client, was she able to get some medication or no?
No, not yet.
All right. I know there's some bureaucracy stuff that goes on between the
Yeah.
jail and,
The MDOC is the one that would dispense it, since my understanding, because she's not in Muskegon County custody, that it had to go through MDOC. So I did send an email to the person in charge of the MDOC, who would be the person that could authorize at least some medication.
how is her headache now?
Not good, I mean,
All right. All right, I did get a copy of the medical records. I'm assuming that we don't want to make those a part of the record, at least certainly not an open part of the record. I guess, how do you guys want to proceed with that? I can make them a confidential part of the record?
I would stipulate to any sort of protective order that the defense would want on these matters.
Mr. Ambrose?
that's fine.
Okay, so I'll make them part of the record. We'll call it the court's exhibit number 1. It'll be a confidential record. The court did have a chance to review those records. It looks like on the 22nd, without going into all the details, it's like on the 22nd, Ms. Vander Ark complained of that she felt like she was going to pass out. I don't think there's any indication in these records that she did in fact pass out. There was some concern with some thyroid issues when she was eating apples, I guess, and they basically told her, don't eat apples. That's what's in the records. So there's nothing in these records about her actually losing consciousness. She reported that she was going to pass out. There's also indication that she asked for some Dramamine for the trip to Muskegon because she typically gets car sickness. So that's kind of in line with the testimony that she felt sick on the way here, but she at least indicated that she gets car sick. So unless I'm missing something, it sounds like they sent her because there was no concern. So based on the records and what we've already done here, I think she's competent, and we're going to move forward today. I am concerned that she reported losing consciousness when a medical person indicates that she complained of feeling like she was losing consciousness, and that she's now kind of amplified for whatever reason, I don't know. But I am concerned about that, the fact that she misrepresented that to her attorney, potentially, that she actually lost consciousness, because there's no record of that in the plea. So, anyway, anything else before we move on, Mr. Ambrose?
Well, the only way that, she would have to report to the medical personnel that she actually did lose consciousness. So,
Well, I mean, okay, I get it, but the quote is, quote, "I felt like I was going to pass out. I have tremors that are severe." That's what she reported on the visit November 22nd, 2025 at 6:45. And she was treated. She says the administrative note was that she was advised on site that the above patient came to the clinic concerned of dizziness and a tingling throat. The tingling throat was transient and only when she ate apples. And it says the RN advised patient had a reddened throat, no swelling, no lymph node enlargement noted, and eventually the treatment is, it says she did palpate in a large thyroid, however the patient is, I don't want to get into that. Says RN still had concerns about patient's fall risk. The RN exam otherwise unremarkable. RN gave the patient detail prior to calling. I advised RN to tell the patient to stop eating apples. Other than that, I did not have orders for this patient. So that's what happened on the 22nd, at least according to the note. Like I said, I don't know what happened, but these are medical records by individuals that I don't know if they'd have a reason to lie, quite frankly, if they're making a medical record. So based on that, I don't see a serious medical issue that is to the concern of the court. So Anything else, Mr. Ambrose, on that? I mean, she can testify if she wants about what she's going through, that's fine, but, if the request is for an adjournment because of a medical issue, I don't see it, so.
If you,
Well, I'm not, listen, no, I'm not gonna delay this anymore. This is, in my opinion, Mr. Ambrose, she's misrepresented, and through you to the court, that she passed out. She did not pass out. So, I'm moving on. I think this is gamesmanship on her part, and it's now 11 o'clock, and a hearing that we were supposed to start at 9 o'clock. The court's been very patient with this, and we need to go, so. Anything else?
No, Your Honor.
Ms. Bloomquist. All right, so Mr. Ambrose, this is your hearing.
Yes.
You can call any opening statements on either side, or you want to just go straight into witnesses?
We can go straight into witnesses.
All right, you can call your first
It
witness.
would be Mr. Johnson. He's-
All right, Mr. Johnson, if you want to come on up front here, sir. Good morning.
Good morning.
All right, would you raise your right hand to be sworn?
Yes, sir.
Matter now pending. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, put your hand down and grab a seat. Please state your name for the record, spelling your first name and last name.
My name is Fred Johnson, FredJohnson.
All right. Mr. Ambrose, you're welcome to stay at the table or the
Okay.
podium, whichever you prefer. So you
Appreciate that.
you can stay standing, stay sitting, it's up to you, okay?
Yes, thank you. Mr. Johnson, you represented Shanda Vander Ark, is that correct?
That is correct.
Okay, and do you recall, you're an attorney.
Yes, sir.
Can you tell us when you became an attorney?
1984.
You know, and I apologize, Your Honor, before we start. Ms. Vander Ark, Mr. Johnson may be getting into some confidential information, you understand that?
Yes, sir.
And you understand that by going forward with this type of hearing, that he's going to relay some confidences.
Yes,
Are you okay with that?
yes, sir.
Do you have any questions regarding
No, sir.
it? Okay. With that disclosure, Your Honor, I'm going to proceed with the
Okay.
examination.
Anything else we should put on the record regarding that you want, Ms. Bloomquist?
No, Your Honor.
Okay, all right, good enough.
What year did you become an attorney?
1984.
Okay, and where'd you go to law school?
Thomas M. Cooley.
And so from 1984, have you always practiced criminal law?
I have always practiced law, yes.
Okay, and has your license, have you continuously been an attorney ever since 1984?
No, sir. My license was suspended last year for 6 months.
And what was that, so it was suspended last year for 6, what was the reason why it was suspended?
Violation of confidentiality, conflict of interest rules.
Okay, and that was while you were a public defender?
Yes,
And when you represented Ms. Vander Ark, you were a public defender, is that true as well?
yes.
And the initial allegation that was lodged against you, when does that go back to?
Oh, gosh, that was, I couldn't tell you the year, 5 years ago, perhaps 6.
And when was the complaint issued against you?
2024 is my guess.
Okay, and
2023 perhaps.
Did you admit to the grievance?
Yes, I did.
And what did you admit to?
I admitted that I had received information from one client while representing another client, and the person who the information I received was the victim in that case, in the second client's case.
And again, this was while you were the public defender?
Yes, sir.
When did you take on that role?
2013,
And
September.
what did your office consist of?
In 2013,
Throughout the years?
it grew over the years.
Okay.
We started, I think, we're at 13, and by the time I left, we were in our 20s, maybe 25, 26.
Okay.
And that includes staff as well.
So you mentioned that you admitted to the allegations within the grievance,
Yes, sir.
and what did you have to do as a result of your suspension?
I was suspended for 6 months, so I could not practice law. There's a fine and costs.
Were you required to take any type of classes?
Was I required to? No, I did. I was not required to. I did, but I was not required to.
What type of classes did you take?
On ethics, conflict of interest.
Okay. And did you testify at any of these hearings?
Which hearings? The ethical issues hearings?
Yes.
Yeah. I don't know if it was testimony or not. I made a sworn statement at the time of my initial interview, and I spoke to the state bar, and I think that was under oath as well, so that both might be testimony.
Okay. And part of your disclosures were that you're more or less overworked. Is that accurate?
Was I overworked? I think I was.
And would you disagree with, I was working too long, I was working too many cases, too much stuff, too many irons in the fire? Is that something that you may have said?
Yes, sir.
Any disagreement about that?
No, sir.
Also, basically, when I was a public defender, I was working on a conveyor belt system, and the problem that came up on the belt next is the one I tackled and tried to keep the other ones juggling until I could fix them as well. Does that sound like something you might have said?
Yes, sir.
Now, this case with regard to Ms. Vander Ark, do you recall when you initially, how is the assignment system conducted in Muskegon County?
You mean back then or now?
When you were assigned?
When I was public defender?
Yes.
Okay. The attorneys are assigned to judges, and whatever case the judge received, that attorney assigned to that judge will receive that particular assignment. Normally that was the situation, unless something came up and then we'd have to change assignment for whatever purpose might have occurred.
Is there a private bar that receives assignments as well, or is it just everything that every indigent client goes through the public defender's office?
Things have changed over the years. Things have changed over the years. Currently, all the indigent individuals go through the public defender's office. There is a private bar, however. Are there assignments to the private bar? On occasion there are, and there were.
Upon receiving the assignment, do you recall when you would have first talk to Ms. Vander Ark?
I would assume it was before the preliminary examination, but I don't have a specific recollection of any particular dates.
At any point in time, at the preliminary examination, with your initial conversation with Ms. Vander Ark, did she ever admit to any type of guilt?
No, sir.
All right. Now, she contended that she was innocent throughout this case, isn't that right?
Yes, sir.
She testified, right?
Yes, she did.
She never admitted to any type of wrongdoing that caused the death of her son.
That is correct.
Now, while you were assigned to the case, did you have Ms. Vander Ark see a professional with regard to competency or criminal responsibility?
I had Ms. Vander Ark see several professionals, 2 doctors, and we employ social workers on our staff.
With regard to, do you recall having Ms. Vander Ark seen by Colin King, Dr. Colin King?
I do recall that.
And in Mr. King's report, did he do a report?
He did.
And do you recall what the results of that report were?
I don't recall the specific results. I recall the conversation we had in regards to that report.
As part of his conclusions, would you agree or disagree that he mentioned that Ms. Vander Ark continues to insist she did nothing wrong and was not convinced that her actions and instructions caused the death of her son?
I don't recall that specifically. If you have the report, it might refresh my recollection, but I don't argue with that statement. It sounds, generally speaking, is what I recall.
May I approach the
You may.
Yes, sir.
And it's an accurate statement that she had stated that to this doctor that she felt that she did nothing wrong, is that correct?
Yes, sir.
And you went to trial on that basis, right?
We went to trial because she was charged, sir.
And she proclaimed her innocence, right?
Even had she not proclaimed her innocence, we would have gone to trial as she was charged with first-degree murder. But yes, she proclaimed her innocence from beginning to end, and we tried the matter.
Were there any offers made to Ms. Vander Ark?
Not that I can recall, Your Honor. Sir.
Now, Ms. Vander Ark testified at trial, right?
Correct.
And she again proclaimed her innocence to the charges, right?
That is correct.
And there was an incident on the day of her testimony where she had a physical reaction to seeing a photograph of her son. Do you recall that?
I believe that was, if we're talking about the situation where she turned and there was a trash can there and she appeared to I don't know if she actually did vomit, but she had, the body language was indicating that's what was going on. I was sitting in a chair over there with the prosecutor.
And during her cross-examination was, you described the cross-examination for us.
Aggressive and effective.
Okay, aggressive and effective. And did you see Ms. Vander Ark after court that day?
I don't believe I went out to the jail to see her after court that day, no.
Okay, did you go into lockup with her after court?
I can't honestly tell you that.
Right. The next day, can you tell us what happens?
And if my recollection is correct, the next day, court was resumed, and my client, Vander Ark, was unable to attend. She was unable to come to the hearing, as I recall.
And you reported that to the court, right?
Yes, sir.
And you stated to the court that she had some competency issues at that point, is that correct?
Some competency?
That she wasn't able to proceed.
Yes, and, yes, sir.
May I approach?
You may.
And this is, I'm showing you a transcript of December 15th, 2023. It's on page 3. You can just read that portion.
Yes, sir.
And so you indicated to the court that she wasn't competent to proceed, is that right?
That is the word I used, sir.
Okay. And describe to us what she was going through.
She was, when I went to visit her, she was curled up in a ball on the floor. She was crying, she was upset. She expressed that she couldn't return to court. She expressed that she was upset, that she was stressed, that she was experiencing, and I'm sorry, I forget the word. She's experiencing a period of where she's so emotional she can't function intellectually.
And based upon that, you reported that to the court.
Yes, sir.
And you also, do you recall reporting to the court as well as that if we waited until, or adjourned the matter until Monday, Tuesday, or Wednesday of the following week, we'd be in the same situation?
I don't recall, but I'm not arguing with that. I assume you have transcripts there. I don't recall saying that, but.
If you look on page 4.
Which paragraph, sir?
The second full paragraph,
Okay.
starting with the word 1.
Okay.
And you agree that you told the court, we couldn't guarantee to the court that as of Monday or Tuesday or even Wednesday of next week, we'd be in any different situation than we are right now.
That is what I said.
And was that an accurate assessment?
That was my assessment at the time, yes, sir.
Do you, okay, so one of the things that you argued to the, or suggested to the jury was that Ms. Vander Ark was guilty of manslaughter. Is that right?
That she was guilty of manslaughter.
Yes.
I don't know if I used that term. I don't recall arguing on the manslaughter issue. Can you tell me which page?
Yes. I have this broken up, but it's on page 84.
Okay. Do I have it?
Yes, near the back.
Okay. We're also in 84, counsel.
It's actually on the very last page, page 89.
Okay.
First full paragraph. And you told the jury, these people, and I'm assuming you meant Paul as well, these people committed manslaughter. That's what they did.
Yes, sir.
They caused the boy's death. That's
Yes,
what
sir.
you're saying. Now, Ms. Vander Ark never gave you consent to say that she was guilty of anything, did she?
No, sir.
And so you kind of took it upon yourself to make that argument to the jury.
Yes, sir.
I have nothing further.
Some questions?
Good morning, Mr. Johnson. How are you?
I'm well, thank you.
So I'm just going to go back a little bit more into your experience. How many years have you been a practicing attorney?
41 this year.
Okay. And how many years of that as the chief public defender for Muskegon County?
From 2013 to 2024, so 11 years.
Okay. Is it fair to say in your role as the chief public defender, you would take some of the more severe cases that the county has seen?
Yes, sir.
Okay.
Yes, ma'am. My apologies.
That's okay.
I'm on a roll here.
Now, just sort of getting into some of the comments that were brought out from your sworn statement or things like that, there's discussions about your workload. Do you
Yes,
recall
ma'am.
that? And maybe feeling like you had a conveyor belt system.
Yes, ma'am.
Did a case like this fall into the same category of cases you were discussing in that?
No, the cases like this get the spotlight. They come out of the group, of the pack, and we place not only my efforts, but the social workers and other attorneys on staff. We all work on cases of this magnitude.
Okay. So although there's testimony by you to the effect of being overworked and that impacting some of your cases, is that an accurate sort of representation of what's said?
It certainly impacted the one where I saw that information and I should have seen it. It impacted there. That's why I think it happened. But I'm sorry, go ahead.
No, and that's okay. And just to be very clear, the case for which you had your suspension had absolutely nothing to do with this case, correct?
That's correct.
No witnesses between, Paul and Ms. Vander Ark. That wasn't the conflict at issue.
That's correct.
Okay, it was a wholly unrelated matter.
Yes, ma'am.
And, while we're on that topic, did you have to sit in that exact same witness chair in a Ginther hearing on that case as well?
Yes, ma'am.
Okay. And you testified about the allegations and the conflict that was alleged?
Yes, ma'am.
So getting back into your prep on this case specifically, let's walk the court through your preparation for trial. Let's start with prelim. Walk us through your preparation for preliminary examination on this case.
Well, I assume all lawyers do. You receive information called discovery, and you pour over it. You go out and see your client. You talk to your client about what's going on and what her impressions are. You come back and you go over it again. You bring in other attorneys to take a look at issues. You run issues back by them, see if they have any similar experiences or any pointers that they may want to bring to bear. You bring another attorney in, usually a younger attorney in, to sit and to watch the whole process. We also employ interns here, so the beauty of interns is, whereas I may have multiple cases, they only have the one, and they pour over the documents and the materials, And if there's anything in there that they see, then they can bring it to my attention. But it's a fallback situation, so we can bring other eyes on it. And there was no different than here, Ms. Vander Ark. We did all these things. We worked dozens of hours just for the preliminary examinations, and we were ready to go.
So it sounds like you created a team, so to speak, for Ms. Vander Ark.
Yes, ma'am.
How many people would you say were on that team?
Over time, coming and going, over time, from the time we got the case to the time we ended, maybe 4 lawyers, an investigator, 2 or 3 social workers, so we're up to 9, and half a dozen interns, so about 15, 16, something along that line.
So 15 or 16 people working on her case specifically?
Over the course of time, yes.
Okay. And as part of your preparation for trial, now let's shift to preparation for trial. You talked about hours for preliminary examination. Could you describe to the court your preparation for trial?
At this point, we've had time, a year, to look at this thing. We've brought in experts to examine my client. We've gone out to the scene of the crime and taken photographs and walked around, got the feel of the place. We've talked to multiple folks who we were considering experts, but we ultimately didn't hire. We spoke to outside social workers to see if any of them had come across any episodes along the similar line. We even saw an article in People magazine about a woman who thrown her kids out the window and then jumped herself. And quite frankly, it was eerily similar. And quite frankly, I'm still convinced there's something to do with my client's conduct. But it was hundreds of hours by then. And I'll put in a couple hundred hours myself on it, and then you add in what everybody else is doing. It's a lot of time. It's a lot of effort. And I told her I think if she had to hire, she'd spend $1 million on what we did for her in terms of trying to prepare and defend her in this case.
So just so I'm clear, you yourself dedicated hundreds of hours
Yes, ma'am.
personally to this case?
Yes, ma'am. It was either I'm reading something or I'm talking to somebody. I'm looking for this needle in the haystack. I believe then, and I believe now, there's something wrong with my client, and that there's somebody out there who would be able to tell me what it was. And I still believe that to this day.
Okay. So I want to dive a little bit deeper. You said that you sought out experts, correct?
Yes, ma'am.
And were some of your experts from the Center for Forensic Psychiatry? The sort of state-run?
We use the appellate defender has a website, and they have a listing of witnesses, expert witnesses that other lawyers have used, and we use their list in determining which ones to approach. We also use here from the other lawyers in the office, have you used anyone in these circumstances? Do you know of anyone? And those are the lists we use.
Okay. And so, I know the record will reflect this, but I want to ask you, do you recall having a criminal responsibility report done for Ms. Vander Ark?
Yes, Dr. Watson.
And do you recall also having a criminal competency report done as well?
Yes, ma'am.
And now those were ones that I believe were filed with the court, correct?
Yes, ma'am.
Were there reports that you, or examinations that were done and reports that were drafted that were not filed with the court on Ms. Vander Ark's behalf?
I don't know if we filed Dr. King's report or not. I don't think we did.
Okay. And did you also get a report from a George Watson Jr.?
Yes.
Okay, and to your knowledge, was that ever provided to any, to the court or to the parties?
To my recollection, no.
Okay. Is it fair to say that you did a lot of investigation into experts who could testify about her mental state?
I think that is fair.
Why didn't you present those experts?
The conclusions the experts provided would have been supportive of a verdict of guilty of murder. Their positions were uniformly and enthusiastically negative towards my clients, they would have been prosecution witnesses and presented their findings.
So you intentionally did not call these
That
experts?
is correct. We intentionally did not call them.
And that choice was made after a thorough investigation of their opinions, correct? Or I guess explain the
Okay,
investigation
okay.
that went into that determination.
Dr. King, for instance, when I spoke to him, his response was, "She's a monster." His response was, "She's the worst thing he'd ever seen." And he's a man who testified for mass murders. I did not want to bring his testimony in. Dr. King simply said that she was competent at the time, she was competent for trial, and he had no, and that's not what I wanted the jury to hear. I want the jury to hear there's something wrong with her.
So let's get into, and I hate to zoom out here from these details, but what was your overall strategy?
The overall strategy was to attack the issue of premeditation, that my client premeditated when she caused the death of this young man. Our strategy was to demonstrate that through especially her text messages, that she was, for whatever reason, unaware that her son was suffering and was close to death. And we tried, especially with her text messaging at the time, to demonstrate that that was the case.
And I know you previously said you were looking for a needle in a haystack for something in your defense, correct?
We were looking for the cause. If you understand the facts involved in this case, this young man was her son. This young man, she could have refused him. She could have refused even to take him into her home. She brought him into her home to care for him. This young man was killed in the most brutal, heinous way that you can imagine, slowly starving him to death. The two, and it probably is just because that's the way I just can't believe that a healthy person would have done the things that she did. I don't believe it to this day.
Now, the realities of this case and the nature of it is something you have to factor in your preparation, correct?
Yes, ma'am.
And you did, in
Yes.
fact, do that?
Yes, ma'am. The evidence? Yes.
Okay. And now you've talked about these hundreds of hours. Have you also, in preparation for this trial, did you engage in witness preparation
Of my client?
of anybody?
Yes, we talked to my client about her role and how we were going to decide once we got there if she was going to testify and the sorts of things she might be asking, the sorts of things that we'd be asking of her. Our only other witnesses would have been the experts had they been called. And so there wasn't anyone, or the social workers. And since we didn't call any of those folks, it wasn't necessary to prep any other witnesses for testimony.
And additionally, in preparation, did you evaluate filing motions to suppress or other sort of pretrial motions
Yes.
on this case?
Certainly, and that was the value of the group thing. You have several lawyers and you're asking them, and an investigator, what about this issue, what about that issue? Should we file a motion on it? Should we attempt to take it to the Court of Appeals if we lose, that sort of thing? All those issues were discussed.
Okay. Did you also prepare for your voir dire in this case?
Yes, it was.
Okay. Are you aware there's an allegation that you did not prepare for voir dire in this case?
Yes.
Okay, and in preparation for today's hearing, did you provide to me some documentation from your file regarding your voir dire?
I did.
Okay. Your Honor, would you like the people to be numbers or letters given today's proceeding?
Let's do numbers. We'll stick with consistency, unless someone's pre-marked exhibits, but we'll do numbers.
Okay, I'm going to be showing, may I approach?
You may.
All right, I'm showing the witness what's been marked as People's Proposed Exhibit 1. Could you identify what this is for the record?
Yes, this is my standard voir dire sheet, which in which 4 pages of questions that I may or may not be asking depending on the nature of the case. But certain things that I want to make sure I cover and ask the juror or potential juror before they're seated.
Okay. Do you recall if you used this preparatory document in your trial?
Yes, I did.
Okay. And I know this is a blank version, but did you take notes on it during the trial, or?
Yes, I
like
did.
that? Okay. Your Honor, at this point in time, I'd move for the admission of People's Exhibit 1.
Mr. Ambrose?
I'm sorry.
There's been moving for admission.
Oh, I have
Exhibit
no
one.
objection.
All right, so Exhibit 1 is admitted.
We can just leave that on there.
Without objection.
What did you do to prepare for voir dire? Was it all contained in this document, or what else did you do?
No, ma'am. The day before, a couple of days before a jury trial, the list of potential jurors are made available to the parties. We got that list, and there's some information, used to be better once handwritten, but now the computer stuff is not as helpful, but there is information, and we, and I say myself and the interns go over this information to discuss potential jurors. We're looking for folks that we want to keep on the jury and folks we don't want on there. And so we're going over these things and we're asking questions back and forth. Do you know these people? Have you met these people? Are these people, are they friendly to us? Will they be hostile to us? And we're going over that list. And so we've got notes. When we come into court, we have notes on the witness list that they gave us as to individuals we may not be called. We may not wish to be on the jury. A police officer. If there's a police officer, we're probably going to ask him to be removed or her to be removed. So we go over that. Then when we get to when we prepare, we're looking at which of these questions are important to us and which ones are not. The way voir dire works, as you know, they're asked, did you hear all the questions and would you answer any different? So you can't ask the same questions over and over. So what I try to do during my voir dire is specifically save out some questions so that every time I take somebody out, I have new questions for them. The whole panel hears them, but they're new questions, and they kind of help keep the interest of the rest of the panel. So that's part of the voir dire preparation. The reality with voir dire is, if you pick a bad jury, the case is over. You're done. You've gotta emphasize that part, because if the jury's not listening to you, it doesn't matter how brilliant you are afterwards. The voir dire has to be effective for your client, so we put a lot of emphasis on it.
And you specifically did in this case.
I specifically did in this case.
Now, is also part of your voir dire come from experience?
Yes, ma'am.
And could you give a rough estimate before this trial how many jury trials you have conducted?
Misdemeanor, misdemeanor and felony, maybe 2 or 3 a year, felonies, and back when before I became a public defender, 10 or 15 misdemeanor cases, literally couple hundred. I don't know. I've lost track a long time ago.
You don't keep a sheet with
Yeah,
it
at
anymore?
least 10, 15 a year for 30 years. So.
Okay, thank you. But you have vast experience in selecting a jury, correct?
I've done it many, many times.
And is part of selecting a jury knowing potential jurors out in the gallery that might be called up if you excuse somebody?
Yes, ma'am.
And I guess, do you see your obligation as a defense attorney to make sure you use every preempt, or to make sure you get the best jurors seated in those seats?
I want the best panel, and I tell my folks, the young folks, it's not how many questions you ask the right questions. You don't need to ask 100 questions. So there are occasions when my voir dire may be brief, but hopefully is effective. And I'm talking, and as Judge Casey will tell you, I talk loud. Everyone in the courtroom can hear me when I'm doing my voir dire. I speak to the people out the back as well as in the panel. So yes, I'm aware of the panel here, but I'm also aware of who's sitting out there in the jury. Sometimes taking a person off the jury doesn't mean you're going to replace them with someone better. That's the Detroit Lions philosophy. Just because you replace somebody doesn't mean they're going to be better. Sometimes once you got the best you have, you stop talking.
Did you feel like you had a good panel in this case when you concluded voir dire?
Every lawyer says, I want a fair jury. We don't. We want a jury that's gonna do what we want. I want a jury that's gonna say not guilty. I got a jury as close to that as I was going to get from this end.
So I'd like to shift a little bit and move into your interactions with the defendant. Do you recall, and it can be approximate, how many times you met with her personally?
Gracious, no. I couldn't meet with her, well, okay, me personally. Gosh. No, it was, I tried to go at least every other month, so we had a year, maybe 6 times, maybe. And then during trial, gosh, and then after trial, and then are you counting the time after trial when I went to Jackson to meet with her?
Well, let's
Or just before trial?
let's say before trial,
Okay.
but then I'll get into the Jackson.
Half dozen, somewhere between 6 and 10, something like that.
And that was while she was lodged at the Muskegon County Jail?
That is correct.
Okay. How did those meetings go? What was the general atmosphere?
The meetings went very well, notwithstanding what she was convicted of. Ms. Vander Ark was a wonderful client. She was a client from heaven. We talked. Her conversations were on point. She used time well. She didn't keep me after the point of the visit was over. She asked good questions. She responded well. We have a wonderful attorney-client relationship.
And so it sounds like she was a cooperative
Oh,
client.
absolutely, always, always.
And she had, would you say, above average understanding of the proceedings and what was coming with the trial?
She's a lawyer. She went to law school. She graduated from law school. She missed one question on her bar examination. She clerked for 2 judges. She must have sat in on a dozen felony murder cases, sat in and watched them. So she had as much experience with the law as somebody who has never practiced could possibly have. She was, and our interactions were tailored towards that. It's not one cookie cutter for every client. Her situation was different. She could understand and put together the facts and circumstances in a way that a layperson couldn't do. And that was very effective for her and very, very, and I appreciated it.
And in those discussions with her, is it fair to say you discussed trial strategy with her?
Yes.
Okay, what was that trial strategy?
The trial strategy initially, and hopefully when we began, was to find that there was no intention, there was no premeditation, and that there was something mentally wrong with the person that committed this offense. Quite frankly, and as I would tell my folks when I first met her, in the first 6-7 months we worked on this, I would tell them there must be somebody else living in that head along with her, because the person I knew and the person who did these things, they just didn't matter. So our hope was to find somebody who could put a finger. This is what she has. This is what's wrong with her. When that proved to be didn't bear fruit, we moved to, okay, when did she perform? When did she create the intention to even injure her son? Because our argument was she never formed it.
Did you discuss manslaughter with her?
Yes, manslaughter, murder in the 2nd degree, all the homicide crimes we discussed each and every one.
And you read portions of your closing argument.
Yes, ma'am.
And did you discuss with her about conceding manslaughter in your closing?
I don't remember that.
Okay. Why did you concede manslaughter?
The volume of evidence and the type of evidence was massive. And if you look at a jury and you tell them that nothing's wrong when it's clear to even somebody hasn't been intention that something wrong's happened, you lose them. And when you lose credibility with the jury, they never listen to what you have to say after that. Quite frankly, I was hoping for murder too. I told them manslaughter because that would give them the space to move up if they, but I was hoping that they would see me as a fair dealer, as an honest person who looked them in the eye and told them, this is what's going on, and I'm not going to try to lie to you or put on lawyer tricks and fool you with the gun. That glove doesn't fit it, you must have quit that stuff. I'm an honest guy, this is what I honestly think, and this is why you should think it. So I had to concede something because, quite frankly, the evidence was overwhelming, and the prosecutor hadn't even put in his best evidence.
And at the time of closing argument, is it fair to say that Ms. Vander Ark was not assisting you in your closing argument, given her mental or physical state in the jail?
We had, before the day that morning, we had stopped talking about what we were doing in court, and it was just a conversation of, will you come to court? That's all we talked about. Will you come to court? And when she couldn't, then we went back to court and we finished up. We had talked about the things I would say, generally speaking, during the course of my representation of her. But the reality is a closing argument is as much art form as in science. I don't know exactly what I'm going to say every time, so I couldn't tell her exactly. She understood the plan. Did she know exactly what I was going to say? No, because I didn't know exactly what I was going to say.
But I want to just clarify, though, your decision to concede manslaughter wasn't an off-the-cuff decision.
Oh, no, it was not. No,
Okay.
it was not.
And you conducted some investigation, and you put a lot of thought into doing that, correct?
Yes.
Okay. So I want to shift gears here into her competency. How many cases have you handled where someone has been referred for competency or criminal responsibility examinations?
3 or 4 a year, so 30 or 40.
Okay. And so have you had situations where you have somebody who absolutely can assist you in any aspect of the court proceeding?
Yes.
Was that the case in this case?
No.
Okay. And during trial, was Ms. Vander Ark alert to her being Ms. Vander Ark?
Yes.
Was she alert to she was in Judge Casel's courtroom?
Yes.
And that it was the date and time that it was that year?
Yes.
Okay. And she was actively assisting you, it sounds like?
She was.
Okay. And was she assisting by writing notes while you were at counsel table?
Yes, and that was what I do is I can't listen to the witness chair and my client at the same time, so I give them a pad and pen and ask them to write notes and slide them over to me.
And without getting necessarily into what she was writing, was the content of what she was writing coherent?
Yes.
It was attuned to time and place?
Yes.
It was appropriate for what was going on in the courtroom?
Yes.
Okay. So let's talk about Thursday after she testified. Now, you don't recall if you went into the holding cell or the jail with her after the testimony concluded?
Okay, let's make sure I understand.
Yes.
When trial was over, did I go into the jail? Okay.
Thank you for clarifying. That was
Okay.
a poorly worded question. When the proceedings on Thursday, not the last day, but the day she concluded her cross-examination,
Yes.
when that day concluded, did you go to the jail to meet with her?
I believe I saw her in the holding cell, which is back here behind the jury room. I think after each day, myself and the social worker involved, we go back and we talk to her for a few minutes, but then we break. That was the plan. Did it always happen every day? I don't remember. I think we did most days. I don't know if we did that day.
So you wouldn't be able to say how she was appearing outside of the courtroom after that?
I have no recollection of her after she walked out of the court that day. Then I don't recall.
Okay. So let's move into that Friday morning
Yes, ma'am.
that you've already testified about. And you described that she was in a holding cell, correct?
Yes, ma'am.
Do you recall who was in the holding cell with you?
My Ms. Vander Ark and my caseworker. Who's my caseworker? social work was there. I'm trying to remember which one it was. No, I don't remember which one.
Would it be Melinda Katecki?
Yes,
Okay.
yes, that was Melinda.
Do you remember a couple of jail deputies also being there?
They were in the area, but they weren't in the cell. There's a cell area, and they stand outside of that. They weren't in the cell with us.
Okay, so to your recollection, it was you, Ms. Katecki, and your client.
That's my recollection.
Okay. And you indicated that she was on the ground curled up?
She's on the floor, curled up against the wall.
Okay. And could you tell the court what your conversation is with her, like at the start of that morning, when you first walk
Okay.
in? What's the conversation?
Are you okay? What's going on? Can I get you something? What are you feeling? Can you explain to me what's going on? What was the situation? Ms. Kotecki was also talking to her the same sorts of questions. What's wrong?
And what did Ms. Vander Ark reply?
Effectively, I can't quote her, that's what she said. Her response was that she could no longer, she could not go up in the courtroom today. She couldn't take the trial today. She was having an episode, and she just couldn't tolerate being in the courtroom today.
Okay. And at some point you come up to the trial court and you place on the record
Yes.
what occurred, correct?
Yes.
And in that you stated you discussed Ms. Vander Ark's options, correct?
Yes,
Did you in fact discuss her options on how to proceed that morning?
yes, yes, ma'am.
Could you explain that conversation to the court?
We explained to her that option one was to come back in the court and just sit there. We're not going to put you on the stand again today, just sit there. Option two was for us to go back and ask the judge to adjourn. That was in fact plan A, to ask for an adjournment to give her, or at least some breathing spell. When this happened a time previously, the judge gave her 5 minutes, but we already had an hour or so in on this thing, so that was plan B. Plan C was to continue to represent her. If the judge said go, we're going to go.
Did Ms. Vander Ark want the adjournment?
Yes.
Did she want, and if the adjournment wasn't available, I guess, did you discuss waiving her right to be present at court?
I don't think, I don't recall. I don't think I did. I don't think I told her that she had a right to refuse.
If she signed an affidavit saying that she is voluntarily choosing not to come to
Oh,
court, would that
yeah.
refresh your recollection?
It does, you're correct.
Okay.
She did sign an affidavit.
Okay. And did you know that that was happening, or were you aware that that was something that was being drafted for her to
Yes,
sign?
yes, I was.
Okay. And so, does that refresh your recollection about the conversation?
Yes, it does.
Okay.
Yeah.
Now that your recollection's refreshed, do you recall explaining to her her ability to waive her presence?
Yes, I remember, in the context of the affidavit, I think we came up and came downstairs a couple of times. And when we came down and said, this is what's going to happen, you have this, if you don't want to be there, you have to let us know, and she signed an affidavit to that effect.
Did you coerce her in any way not to come to court?
Okay.
Okay. Did you want her to come to court?
Yes, ma'am.
Would that have been better for your case if she came to court?
It would have been better, yes, ma'am.
Did you feel like she understood what was happening to sign that affidavit?
Yes, ma'am.
Or at least to make the choice to not come to court?
Yes, ma'am.
I apologize, I shuffled my notes here. Now, when you were asked about using the word competency, I believe it was
Yeah.
on page 3 of that transcript you have there, you said, well, that's the word I used. Could you explain your response to that question?
I used it in the layman's vernacular as competency, not as in the legal standard as competency. I didn't mean that she, as lawyers know, that she couldn't participate or that she couldn't understand. I didn't mean it. I meant as a layman would use the word competent. She just wasn't ready to go. She wasn't able to write me those notes or to whisper in my ear or to participate as I would want her to have. Her life's on the line. It's a murder trial. I want her to be fully able, I'm going to say competent again, to participate in the process. This is her chance. This is her chance. And I didn't want her to leave that courtroom thinking that she left cards on the table or whatever the expression might be.
So it was not your impression that she was legally incompetent the morning of that Friday morning?
That is correct.
Now, had Ms. Vander Ark, and I know the court's referenced this before, but Ms. Vander Ark had episodes before, correct?
In my presence, she'd had, if we're not talking about when she saw the photograph, in my presence, she had one episode, but she expressed to me during the course of our representation that she'd had others.
Okay. And one of those episodes, and correct me if I'm wrong, but you observed the episode at the preliminary examination where her co-defendant was called to the stand and she had an episode, correct?
I don't remember the timing. She had the episode of the freedom.
Okay. And the record will speak for itself about when?
Yes, ma'am.
Okay. Shifting gears a little bit, now, it wasn't your strategy to discuss hydration in depth, was it?
Was it my decision?
Dehydration and,
No.
okay. Why didn't you focus on dehydration?
It seemed to me that dehydration, along with the corporal punishments, along with deprivation of food, along with all the other burdens that young man had to go through, were part and parcel of the same issue. Our argument was she did not form the intent to injure this child. So whether she injured him with dehydration, or she injured him by starving him, or she injured him by thermal, it wasn't an issue. The issue is, did she intend? Did she know? Did she create the intention in her mind to hurt this boy? And that was the issue. So I didn't concentrate on the other issues that the coroner said went into causing his death either, because they just weren't the issue I wanted this jury to concentrate on.
Okay. So that was a conscientious choice on your part?
Sure, we weren't arguing that he was dehydrated. We weren't arguing that he passed away. That he was underfed. We weren't arguing any of that. We were arguing intention.
Do you think if you would have argued that he didn't have his water access restricted, that would have furthered your strategy at all? Or presented the case in a better light for you?
I think I would have lost the jury on that. They had photographs of this boy. And nobody's going to take a look at those pictures and say, this boy needs water.
Now, there's been a claim that you provided deficient performance for allowing commentary in lieu of a video. Are you aware of the video that I'm mentioning?
Yes. The
Okay.
best thing I did in that trial was the best thing that happened in that trial was the fact that that video didn't come in. That video is literally the worst thing I've ever seen. There is no commentary that can express to a jury how bad that video is. The commentary was by leaps and bounds better for our client in showing that jury that video. I'm so pleased and grateful that the people did not push to admit it. That video is just awful. And to the day I died, that was the right strategy. It's the best thing we did during trial was keep that video out. It is just awful. You see it, you'll never forget it.
And just to go back a little bit and expand this, were there in-chambers discussions between yourself, Mr. Roberts from the prosecution, and the court about this specific video and the presentation of it to the jurors?
Yes, ma'am.
Okay, could you just sort of place on the record the summary of that in-chambers
My
communication?
position was that the video was so prejudicial that nobody who saw it could unsee it and not give it and not absolutely close on. It's just, it was, and given the weight of all the other information that Mr. Robertson presented, it was duplicative, and therefore we shouldn't allow it in. That was my argument. Ultimately, as I recall, Mr. Roberts just agreed not to use it.
But-
We use this description, but we wouldn't use the actual video.
But that was due to a strategic stipulation, correct?
Yeah, that was big. That was one of the best things we did.
And it wasn't an oversight that you just let hearsay in
Oh,
about it?
no, ma'am. That was a relief.
If I can just have one moment. Okay. All right, thank you, Mr. Johnson. I have no further questions.
Thank you.
All right, Mr. Ambrose. Any follow?
You mentioned that the morning of December 15th, 2023, Ms. Vander Ark was on the floor, curled up.
That's the day when she refused to, when she declined to come to court? That, were you talking about, counsel?
Yes.
Yes, sir. That's how I found it.
And you did you used the word competent, but you stated that you were using it to the court as part of a, in layman's terms rather than a legal definition.
That's correct.
After the trial in this case, do you recall providing any interviews with the media?
I believe they were standing in the corridor,
Okay.
and I believe they did speak to me.
Do you recall telling, when asked a question about your conversations with, or your interactions with Ms. Vander Ark, that she was in a catatonic state?
I may have used that term, yes.
Okay. And so that's kind of a serious situation, right?
Yes, sir, it is.
And that's more or less what you reported to the court, is that correct?
Catatonic state is a more egregious, is a higher level of incapacity than I reported to the court, and it's what I report to the media.
Yeah, there was some testimony regarding dehydration, and it was your decision. Was it trial strategy that you did not use dehydration as a way to explain the death of Timothy?
Was it? Yes, sir. The trial, would you like me to, the answer to
Yeah,
the question
go ahead.
is, okay. The trial strategy was not to try to explain, that there was food in the house. There was water made available. The other children had corporal punishments as well. The decision was not to try to explain that these were causes of death. The decision was to explain that my client never intended this outcome. Is that?
Was there, to your understanding, was there any restriction on water
For
Timothy?
no, not that.
And when's the last time you saw the death certificate?
The, I would have seen it before trial,
Okay.
other than the last time.
May I approach the witness?
You may.
This was, it looks like it was People's Exhibit number 45 introduced at trial. Is that what you recall as being the death certificate?
I don't have any personal recollection, but this is the death certificate of the victim in this matter.
Okay, and what's the first thing that's listed
Okay.
as being the cause of death?
Okay. What box is that in? Do you know what?
36,
Okay,
near the bottom.
okay, 36. Dehydration and extreme emaciation.
Okay, and dehydration would be lack of fluids, right?
Yes, as far as I know.
And like you said, there was no restriction on water in the household.
That's what my understanding was. I wasn't in the household, so I don't know if it was or not, but that was my understanding.
All right, I have nothing further.
Ms. Mukos, any questions?
If I could just ask a brief follow-up.
Yeah, go ahead.
So, Mr. Johnson, if you had focused on dehydration, would that open avenues to the prosecution to enhance some of their arguments?
I would assume.
Such as the fact that he didn't have access to water when he was locked in the closet, correct?
I didn't want to get into that.
That he did have access to water in the ice baths, arguably.
That's what I was afraid he'd say.
And ultimately, and unfortunately, but by the defendant's actions, Timothy was so malnourished and unable to move that he could not get himself water. Would that be accurate?
I will assume that's the case. At the end, I'm sure that's what the case was.
So there's multiple arguments and pitfalls if you were to take that strategy, correct?
If I would have attempted to argue that whatever in here did not cause the death, I opened the door for Mr. Roberts to show that, okay, it did, and that this wasn't an issue. And I didn't want the jury to hear more of that. I want them to hear that my client just didn't get it. That was the message.
Thank you.
Any thought to that, Mr. Ambrose?
No, you're right.
Okay. Mr. Johnson,
Sir.
I have some, well, it's a noon hour. Are you available this afternoon, Mr. Johnson?
Yes, sir.
Okay, all right. Let's break. We're gonna, since we lost some time this morning, I'm gonna have us return at 1 o'clock after lunch. And then we'll resume. Mr. Johnson, you can stand down for now. I would like you back here at 1 o'clock.
Yes, sir.
All right. Anything before we break, Mr. Ambrose?
No, you're right. Thank you.
Ms. Blomquist?
No, Your Honor, thank you.
All right, we are in recess for lunch.